Bam! Welcome, everybody. Welcome to another episode of The Branca Show. I am, of course, attorney Andrew Branca. Thank you for being here with me today to talk about a tragedy that could have been far worse than it was, that was prevented from being far worse by the aggressive action of American ROTC students in Virginia. Yesterday, a convicted terrorist, Mahomed Bailor Jalloh, entered an ROTC class at Old Dominion University in Virginia, armed with a rifle, shot and killed the instructor, shot two other students. The tragically murdered instructor was Lieutenant Colonel Brandon Shah, a combat veteran and retired Army officer who served as the ROTC program instructor and a military science professor at Old Dominion University. Fortunately, that was as far as terrorist Jalloh got, because other students in the classroom swarmed him, subdued him, and ultimately ended his life, with reports of as many as 22 knife wounds being inflicted on the terrorist killer, despite the university prohibiting the carry of weapons in classrooms. Of course, this event raises the opportunity for us to explore the boundaries of use of force law. As you know, that's my day job. Lawofselfdefense.com, criminal defense attorney with an expertise in use of force law. By the way, you can get this book for free. We give this book away for free. Law of Self-Defense Principles at lawofselfdefense.com/free book. Lawofselfdefense.com/free book. I'll pop that up on the screen right there. Anyone would like to get a copy. We only ask that you cover the cost of shipping the book to you. The book itself is free. All right, so let's jump into this. And I know a lot of you are thinking, well, obviously he's a murderous terrorist. Can't you just do anything you want to him? The answer is no. Nope. Even in the circumstances, there are limits on the legal boundaries within which you can use force against this guy, whether you like it or not. We'll also talk about the knife issue being without permission present in the classroom. So let's share this news story on this event just to get some of the basic facts down. Old Dominion shooting is being investigated as an act of terrorism. Well, I would think so. Authorities are investigating a shooting at a Virginia college Thursday that left one victim dead, two injured, as an act of terrorism, says FBI Director Kash Patel. Gunfire erupted shortly before 11 a.m. in the ROTC classroom at Old Dominion University in Norfolk, Virginia. The victim, Lieutenant Colonel Brandon Shah, an ROTC instructor. I'm not going to share what Virginia Governor Abigail Spanberger has to say. The other two Army personnel were injured. Two other U.S. Army personnel were injured. The gunman, a former member of the Army National Guard who previously pleaded guilty to terrorism-related charges, was also killed in the shooting. The FBI identified him as Mahomed Bailor Jalloh. Dominique Evans, a special agent in charge of the agency's Norfolk field office, said he shouted, "Allahu Akbar," and was subdued by students who, quote unquote, rendered him no longer alive. While law enforcement officials have not yet confirmed a motive, we may never know the motive, folks. How shocking is that? We may never know the motive. Federal authorities said in the previous 2016 case that Jalloh was involved in a plot to murder U.S. military personnel. Well, we let him do that in the end, didn't we? He traveled to North Carolina in 2016 to attempt to buy an AK-47, but the gun owner refused to sell it to Mahomed. He then bought an AR-15 at a local gun store, July 2016, and was arrested the next day. Apparently, he was sending money to ISIS and to FBI agents pretending to be ISIS, which is how they picked him up. He ultimately pleaded guilty to attempting to provide material support to a designated foreign terrorist organization, was sentenced to 11 years in prison. By the way, the prosecutor in that case, the federal government, asked for much more time than this, almost double this amount of time. And the judge decided to give this terrorist supporter a break. And then he got released 5 years, a few years earlier than his sentence. Released in 2024. Let's see, anything else substantive here? Let's talk about Lieutenant Colonel Shah. That's worth discussing. Tragic loss. Lieutenant Colonel Shah was a professor of military science and a department chair at Old Dominion's ROTC program. He was commended in 2023 for increasing enrollment in the ROTC program by nearly 50%. He enlisted in the Army in 2003, was deployed in support of military operations in Iraq and Afghanistan, was awarded 2 Bronze Stars. His cousin also served in the Army, so they were proud to serve our country together. The family came to the U.S. from Pakistan. Well, apparently he fully assimilated. All right. Mr. Guns and Gear, a good follow in X, says, reportedly the killer at Old Dominion today, Mahomed Jalloh, was he writes, foreign, savage, Muslim jihadist from Sierra Leone who was a former Army National Guard member from 2009 to 2015. By the way, he'd become a naturalized citizen. So he was an American citizen. Does he seem to be a genuinely assimilated American citizen? Or a paperwork, credentialed American citizen whose allegiance is actually not to America, but in this case to ISIS, effectively a different sovereign. Former Army National Guard member, 2009 to 2015, was convicted of providing material support to ISIS in 2016. I just want to point out that when we have these discussions about illegal migrants, there's also a discussion to have about legal migrants. This guy came to America legally. He jumped through the hoops that we, pathetically low hoops that we require for granting our nation's most precious resource, American citizenship. And then he did this. He did this. First, he sent money to ISIS. And then he did this act yesterday. Prior to his arrest in the 2016 terrorist funding scheme, he spent 6 months training with ISIS members in Nigeria before returning to his home in Sterling, Virginia. He was released from prison in 2024. I've got a question, and I guess this is a photo of him from a younger age. Why was he not denaturalized? If we have a naturalized U.S. citizen and he's sending money to a designated terrorist organization, ISIS, is convicted, sentenced to years in federal prison, why is he not denaturalized? How does that not automatically happen? And then, of course, after a sentence, immediately deported back to Sierra Leone. Why is he free to walk around on our American soil, even if he weren't committing additional crimes, much less free to walk around on American soil, murdering Americans? Why? Who's answerable for this? My buddy Costas Moros, lawyer in California, does a lot of great Second Amendment work, writes, responding to C.D. Salamander, heroic ROTC student jumped into action before more damage was done, stabbing Mahomed Jalloh to death after the crazed suspect gunned down the class instructor. And Costas writes, what a total badass, love it. But again, an innocent man is dead because we released this monster after he attempted treason by seeking to help ISIS. By the way, that's what he was convicted of, merely attempting to send ISIS money. I believe he actually sent ISIS money, and then he pled to a lesser charge. It's a great heroic student, prevented it from being worse, but such heroism should have never been needed. The perpetrator should have long ago been put to death. Absurd. He was let out. By the way, he was sentenced to 11 years in 2017. So that would have brought him to 29. But he was released early in December 2024. Coincidentally, the last month that Biden was in office, anyone think that was a coincidence? The numbers of commutations and Biden and pardons Biden released at the end was unbelievable. Here we have this FBI agent. Gal runs the local FBI office. Let's hear what she has to say. Pump up the volume a little bit here. Here we go.
How was he deceased?
There were students who were in that room that subdued him and rendered him no longer alive. I don't know how else to say it, but they basically were able to terminate the threat.
So he was not shot?
He was not shot.
He shot 3 people?
Correct. We have information that he shot 3 people.
The one that went to Virginia?
All right. Of course, the memes come out. This is a great cartoonist whose name is not on the image. I can't remember his name. The name he goes by. Does a lot of great cartoons. College kid goes and breaks the chart. So the chart, of course, is, should you bring this to that? And the green ones are yes, and the red ones are no. A knife to a knife fight. Sure. A knife to a gunfight. Nah. A gun to a gunfight. Sure. A bucket of water to a, a gunfight. Nope. A bucket of a lid. A lid. A lid should go on a pot. And another one here. Whoops. Whoops. That's not what I wanted. I wanted this. Here we go. Old Dominion students heard a couple gunshots and somebody shouting in a weird accent, Allahu Akbar, and pulled up like this. The knives came out. The knives came out. Interestingly enough, the knife was actually unlawful. Unlawful. Here's the provision. It's kind of small, so I'll read it to all of you. Possession of weapons prohibited on Old Dominion University campus. Possession or carrying of any weapon by any person, except a police officer, is prohibited on university property, in academic buildings, administrative office buildings, student residence buildings, or dining facilities, or while attending sporting, entertainment, or educational events. Entry upon the university property described in this section, which is everywhere, in violation of this chapter is expressly forbidden. A zero lawful weapons zone. We're going to talk more in a moment about what could happen to the student who had the knife, stopped the terrorist, inflicted the stab wounds. My buddy Costas, again, he writes, the university will just pretend this policy doesn't exist for this one instance because they don't want the mess of going after a hero, but they'll keep it in place in the future. Let's be 100% clear. Lives were saved today because a student chose to ignore an immoral rule. Let's see. Roman Helmet Guy writes, apparently you can try to commit a terrorist attack on U.S. soil and be back on the streets in under 10 years. This is the man who murdered a retired officer yesterday. He was sentenced to just 11 years in 2017. He didn't even serve his full sentence. Theo Wald writes, allow a legal immigrant from Sierra Leone named Mahomed Jalloh to become an American citizen. Step 2, he goes to jail for trying to join ISIS. Step 3, release him before his maximum sentence is up. Step 4, allow him to remain in America instead of denaturalizing and deporting him. Step 5, shoots 3 people at a university. Our civilization simply will not survive if we don't end our suicidal mass immigration policies. But this is how crazy our world is. This is how crazy our world is. The Commonwealth, Norfolk attorney is this guy, a Soros district attorney. Another one, let's hear what he has to say about this. You think he's going to blame the killer, the terrorist, Mohammed, for this tragedy?
Is a national sickness. We live in a country where people care more about guns than they care about 6-year-old children. They care more about guns than they care about synagogue worshipers. And they care more about guns than they do about college students. What that means is that it does not matter how hard President Hemphill works, how hard the chiefs work, somebody will be a victim eventually. It is a matter of time. And until there is the political will to break the spell of the cult of gun absolutism, you will see more incidents like this. So if you are looking for somebody to blame, don't look at anybody up here. Look at our lawmakers who don't have the courage to implement sensible gun control measures. Look to a Supreme Court that enables them, and do something about it. So that is the lesson. Let's mourn the people who have died. Let's decry what has happened, but let's keep the focus where it belongs. It belongs on us and having to change something so that we don't have to suffer through this.
I would suggest it belongs on the killers. On the killers. I mean, by this guy's rationale, we could say, well, we care more about importing terrorist killers than we care about 6-year-olds, right? We care more about importing migrant terrorists than we care about synagogue attendees. By this guy's reasoning, because DUI homicides occur, well, we should get rid of all the cars, obviously, because the DUI homicides are going to continue happening as long as we have cars available to people. Get rid of the cars and you won't have the DUI homicides anymore. Makes perfect sense to this guy. By the way, Virginia is about to pass some of the most egregious gun control I've seen in a very, very long time. Because, of course, the Democrats have seized a bare majority in the legislature and the governor's office, and I think by 1%. And now, of course, they're taking over the whole state, like a metastatic cancer. As this account points out, the shooter here, Mahomed Jalloh, was a convicted felon in possession of a firearm, illegal, in a gun-free zone, illegal. He murdered one, illegal, attempted murder, and assaulted 2 others with deadly force, illegal. That's like 8 laws he was already breaking. And this F-tard thinks more laws would have stopped him. Gun control laws obviously only have an effect on people who obey the gun control law. And anyone committing to commit murder is certainly not going to not commit the murder they wish to because there's a gun control law. Again, a lot of coverage from my buddy Costas today. So the government releases a treasonous radical terrorist, and it's gun owners' fault, and we need to be disarmed. Well, all the people in that classroom either were disarmed or were intended to be disarmed by the rules. How did that work out? Makes sense, Costas writes. We'll keep releasing criminals until you surrender your rights. Another great point by him. It's simple, really. Any government that bans carry at a place but does not secure that place is aiding and abetting terrorists and other killers. Such laws are unconstitutional, and they're also deeply immoral. I couldn't agree more. You know, in the gun control cases from the Supreme Court, they mention, well, you know, you can still limit the Second Amendment in sensitive places. And I'm sure when they wrote those words, what SCOTUS had in mind was like the secure areas of airports, courthouses. There's places where arguably you don't want people to have guns. But the efforts you take there then are to ensure that no one can have a gun. That's why you go through security at an airport. That's why you go through security at a courthouse. If you just ban the guns and you don't make sure that bad guys can't bring them, then all you've done is create a cohort of helpless victims. Another point by Costas here. Today's events are further evidence that you should be carrying everywhere you are legally able and fighting fiercely against state restrictions on so-called sensitive places. Because when SCOTUS says, well, you know, we'll allow for infringement of the Second Amendment in sensitive places, what the gun controllers do, what the Democrats do then, what the lefties, the progressive fascists do is literally they'll label, like New York State, they tried to label the entire state a sensitive place. These are not people who are engaging in honest discussion and policy making. These are zealots And when someone wants to disarm law-abiding people, it's not because they have the interest of those law-abiding people in mind. It's because they wish to do things to those law-abiding people. They wish to allow things to be done to those law-abiding people that those law-abiding people being armed would make difficult to do. They don't want it to be difficult to do those things to you. Costas. Today's events are further evidence that you should be carrying everywhere you are legally able and fighting fiercely against state restrictions on so-called sensitive places unless they offer comprehensive security screening. The Second Amendment Foundation is doing what we can on the legal front and have stopped some of the worst attempted abuses. Unfortunately, in anti-gun states, getting a carry permit can be quite long process. The best time to start that process was months ago, but the second best time is now. And then he recommends a place to get a training in LA. And I'm sure it's a good recommendation. Costas wouldn't send you to a bad place. And of course, this Mahomed Jalloh shooting yesterday is not an isolated event. It's not an isolated event. Also yesterday, we had a synagogue shooting. Bill Malugan writes, DHS confirms that the Michigan synagogue attacker just yesterday has been ID'd as Ayman Mohammed Ghazali, a Lebanese national who first entered the U.S. in 2011 on an immigration visa as the spouse of a U.S. citizen, another legal migrant who became a naturalized U.S. citizen just 5 years later. That's all it takes. Do people really believe that someone named Ayman Mohammed Ghazali from Lebanon can become an assimilated American citizen in just 5 years? Naturalized to a U.S. citizen in 2016 during the Obama administration. Unbelievable. Now, this guy also didn't get far. I haven't looked closely into this case, but my understanding is that he basically crashed his car into the synagogue and was immediately lit up and neutralized by synagogue security, which set the car on fire. Their gunfire set the vehicle on fire, which is the imagery most of us saw. I'll take a closer look at that case, but just another example of a legal migrant allowed into America, allowed to become a naturalized American citizen, who then turns into a murderous terrorist on American soil. Remember the shooting in Australia? The father-son team? Another devout Muslim, Naveed Akram, both father and son Muslims. Also, just a few days ago, March 10th, a Senegalese Muslim, another Muslim, just shot 17 in Texas. And of course, we just had the New York City attempted bombing. A Turkish and an Afghan Muslim threw nail bombs in New York City. We covered that here. The list of Islamic terrorist attacks in Europe and America, and of course Australia, since 2012 could fill a 3-volume book set. Is diversity our strength? Is diversity our strength? You know, and a lot of people were publishing lists of numerous recent Muslim terror attacks. Here's one of them. I'm going to share a few for a reason. In 2 weeks, 4 Muslim terror attacks, 3 Americans now dead. And of course, it could have been much worse. Texas, the bar shooting by the Senegalese. New York, the attempted nail bombing. I mean, thank God the bombs didn't go off. Imagine how many dead and maimed we'd have if the bombs had been competently instructed. Michigan, Virginia, a bar, a protest, a synagogue, a school. Only one common denominator, Islam. Now, the reason I want to show a number of these lists is because it really struck my eye. As I saw more of these, I realized that they're not the same lists. So each list has a slightly different collection of these events. We're under attack. America is facing a growing threat from Islamic extremists. Attack at Temple, Israel. Shooting at Old Dominion University. Attempted bombing in New York City. The Austin bar shooting. And of course, we have these images here. His upper left here, is the New York City bombing. To the right of that, the Austin, Texas. Below that is the, what's that guy from? Oh, yeah, he's one of the attempted New York City nail bombers. And of course, Mahomed Bailor from Old Dominion yesterday. This must stop now, this account writes. This is exactly why we are outspoken about Islamic extremists gaining influence and attempting to take over parts of the country. This is exactly why we look at what's going on and refuse to stay silent. These aren't random. They share radical Islamic ideology, hatred for America, our values, our freedoms, fueled by groups like ISIS. No more excuses, no more political correctness while America dies. Another list from DC Drano. Oh, I've got him blocked for some reason. I wonder why. Muslim terrorist attack in DC killed one U.S. soldier, severely wounded another. Remember that? That wasn't on the prior lists, right? Muslim terrorist attack in Syria killed 2 U.S. soldiers and a civilian interpreter. Muslim terrorist attack at Brown University killed at least 2 students. Muslim terrorist attack in Australia that killed 11. All in the past 2 weeks. He's writing this in mid-December. But there's so many of these events that you actually forget until your recollection is refreshed. You're like, oh yeah, I remember that now. But there's too many to even hold in your mind at one time. This account notes, Islam, and this was posted just today, Islam is not a religion of peace. What jihadis have done in the last 2 weeks, shot up a bar in Texas, killed 2, threw a Molotov at Christians in New York, the nail bombing. Well, I guess that's a different one. See, it's another. More. Threw a nail bomb at Christians in New York, tried bombing a Southwest flight. That wasn't on the other list. I'd forgotten about that one, and it just happened a few days ago. Threatened to bomb a Southwest flight, had to be removed from the plane. Threw an IED at a protest in New York, bomb threats at different airports. People had to be evacuated. I can't remember now if it was Kansas City, one of those regional airports, because of a bomb threat. He writes, Islam is a disease, and funny enough, what do most have in common? New York City being a hotspot. And again, another list. Look how long it is, dating all the way back to September 11th. Shoe bomber, Beltway snipers, Fort Hood shooter, underwear bomber, coal bombers, Madrid train bombers, Bali nightclub bombers, London subway bombers, Moscow theater attackers, Boston Marathon bombers, Pan American Flight 93, Air Force, Entebbe hijackers, Iranian embassy takeover, Beirut U.S. Embassy, Libyan U.S. Embassy, Buenos Aires suicide bombers, Israeli Olympic team attack, Kenya U.S. Embassy, Khobar Towers in Saudi, Beirut Marine Barracks bombers, Beslan Russian school attackers, First World Trade Center bombers in the basement of the building, Bombay and Mumbai, India attackers, the Achille Lauro cruise ship hijackers, September 11th. And this is a tiny fraction of all the acts of terroristic violence. A tiny fraction. And my buddy Costas, again, he's getting a lot of coverage today on my show. He writes, remember that it's okay, it's permissible, it's constitutional for Congress to filter potential immigrants through an ideological criteria. The First Amendment doesn't apply to people who have not been admitted into the people of the U.S. Constitution yet. We need to do a better job of this. Immigration can obviously be very good and beneficial, maybe, but only if the people entering are compatible with our society and willing to integrate and assimilate. If not, it's destructive, horrifically so. When several terrorist attacks, 4 in just the last couple of weeks, have been committed by naturalized immigrants or their children, clearly we can do a better job at only letting in those who actually want to partake in the American experiment peacefully, productively, and not those who wish to undermine and destroy it. Yeah, almost all of these recent terrorist attacks were by naturalized American citizens or the children of first-generation naturalized American citizens. This system is broken, profoundly so. All right, let's transition into the use of force stuff. Let me catch up on the questions and comments, and no Rumble rants today. No Rumble rants today. You guys let me down, Rumble. And I'm also streaming this on the Law of Self-Defense website. Again, lawofselfdefense.com. That's my day job, criminal defense attorney, internationally recognized expertise in use of force law. My book, The Law of Self-Defense Principles, we give it away. We give it away. You can check it out on Amazon, but don't buy it there. Check the reviews, 5-star rated. But they'll charge you $20 or $25 for the book plus shipping and handling. We only ask you to cover the cost of shipping the book to you. The book itself is free. The link is right there at the bottom of the screen. lawofselfdefense.com/free book. All right, super chats. Got a few of those here. Hey, we got a new member. Look at this, Rhonda. Welcome to the family, Rhonda. Of course, we are all watching this show right now in real time, Stopping Terrorism Lawfully, right after we wrap this show up. We transition immediately into our second show of the day, our members-only show, which is going to be on a scathing, fiery exchange of opinions in the Ninth Circuit Court of Appeals about a decision just handed down that says the state of Washington can force a Korean-style spa with traditional communal baths in which women and girls as young as 13 soak in the nude, that Washington State can force that facility to allow in transgender women, meaning men with intact genitalia, get to soak in the tub with the women and the 13-year-old girls. Washington State can force this Korean spa, otherwise exclusive to women, to accept those men. Unbelievable. And one of my favorite judges, Judge Van Dyke in the Ninth Circuit, wrote a scathing response to this, as did some other judges in the Ninth Circuit. So that's going to be our members-only show. We're going to break that case down for you. It's only 16 cents a day to be a member, folks. $5 a month, you get double the number of Branca shows. The link for the show and the link to become a member, all that is in the description. In the description. But right now, we're here. Yeah, so become a member like Rhonda. Join the family. Join the family. We have a lot of fun. Bush McFadden, $5. When Republicans said, don't bring a knife to a gunfight, leftists don't understand that included spoons and forks. Seems pretty good to stay home. Dirt Cheap, $5. My local news. Up next, what did he shout before entering the classroom? He shouted, is this ROTC? I guess he did ask that. I've seen that reporting. Because he wanted to know he was in the right place to commit the killings he intended to commit. He wanted to kill ROTC personnel. He also shouted Allahu Akbar. Which of those two shouts do you think is more relevant as to why this event occurred? They make it sound like he was just a student wandering around, wanting to make sure he was in the right classroom. Unbelievable. I saw so much reporting that only mentioned his last name, Jalloh. Didn't mention his first name, Mohammed. Joshki, $5, says, are we assuming it was a knife and they didn't John Wick the individual with a pencil? With a pencil. What a great movie that first John Wick was. I have to admit, the later John Wicks kind of didn't grab me with the same intensity. I'd rather be skiing, $10. What effing sort of nonsense are these morons yapping about? Anyone pushing disarming of law-abiding citizen defenders is an enemy of all free people and should never be in a position of power, in my opinion. Yeah, I couldn't agree more. Again, they're not disarming you because they have your best interests at heart. They're disarming you because they want things done to you that you having a gun would make difficult. Josh Key again, another $5. Is the college now liable for harms they allowed to happen and should be sued? So that's a great question. It comes up quite a lot, and the answer is no. So you would think that if a school or business, if they put up a no guns allowed sign, so you're only allowed to come in if you're not armed, no weapons allowed, whatever the case may be, shouldn't they be liable if something bad happens to you because they required you to be disarmed? And the answer is no, because you're not required to go in. You chose to go in disarmed, right? You saw the sign, you could have turned around and gone someplace else. So you chose to go in unarmed. That allows for an inference that even you didn't believe you needed to be armed there, or you wouldn't have gone in. If you believed if I go in unarmed, I could be subject to death or serious bodily harm, you wouldn't go in. A rational person wouldn't go in. So that's the argument. Another variant of that is you're accepting the risk. You're accepting the risk of being present on the property unarmed. That's on you. That's the way the legal argument goes. American Jane just became a member. Thank you, Jane. Welcome to the family. And Josh Key again. Josh Key's busy here today. If these individuals were Christians, it would all be labeled hate crimes and prosecuted as such. Yes, of course. Of course it would. There'd be people complaining about it. Systematic. What would they call it? Ethno-Christian, fascist, terrorism. Something must be done about all these Christians. We'd never hear the end of it. And I did get a Rumble rant. Thank you for streaming on Rumble. We're glad to see you on Laura's show. That one time, great appearance. Yeah, I've been on Laura Ingraham's show a few times. That last time was really funny because I was in a hotel in Florida for Tim Pool's show. And Laura Ingraham Fox asked me to come on. And I thought I would just be streaming from my hotel room. They actually sent a van to the hotel. That's a studio. It's a studio on wheels. It was a very interesting experience. Thanks for that, man. I appreciate that. Let me check out Law of Self-Defense membership. Let's see if I can make this bigger, easier for me to read. Yeah, so if you get the book, you might also consider becoming this book, links at the bottom of the screen. You might also consider becoming a Law of Self-Defense member. We do a lot of use of force analysis there that's just for our members. High-profile cases like this, we tend to share more broadly, but most of our content at lawofselfdefense.com is locked down for members. So let's see. What kind of knife was it? I don't know. We haven't seen it reported. Was it an Uncle Buck pocket knife? You know, when I was in high school in the early 80s, I carried a buck knife in my back pocket in the New York City metro area every day. And it wasn't hidden. I mean, I would open up envelopes for the teachers and stuff like that. It was the most normal thing in the world. Uncle Buck pocket knife, a bayonet, what was it? Whatever, if we discover the make and model of this knife, man, that company is going to move a lot of product. Danny says, was this caught on video? I haven't seen that reported. It's possible. It could have been. A lot of classrooms these days have cameras recording the instructors, so we'll see what happens. Let's see. Members coming in to the chat. Let's see. Danny says, it appears AR-15 sales are going to dry up in Virginia. Virginia's trying to make it essentially impossible to own an AR-15 in the state. Someone's recommending I get a clip-on tie. Nope, no clip-on ties for me. Let's see. Just looking through the member chat here. Okay, I think I'm caught up there. And a couple more super chats. Hey, DJ Laser's been a member for 8 months. Thank you, my friend. I appreciate that. Long-term supporter. And Eclectic Deb, also a member for 6 months. Says, perhaps the Trump administration should remove any funding to a school that violates our Second Amendment with their policies. Yeah, that would be interesting. That would be a very pleasant policy position to see. All right, so let's talk about the legal dynamics here. Guy comes into the classroom. First of all, he walks in with a rifle, right? Now, I know there's lots of open carry people in my community. They want to open carry pistols, so they're not concealed. They want to open carry long guns. And I don't have any objection. I have to say, I personally, the only reason I would ever open carry would be if that was the only legal way for me to carry a gun. If I have the option to carry concealed, I'm going to carry concealed. I don't want anyone to know I have a gun on my person until they need to know that I have a gun on my person. But I think open carry is captured within the Second Amendment. I think we all have all law-abiding, mentally sound American citizens have a fundamental right to open carry for lawful purposes if we wish to. Having said that, I can tell you that if I'm in a Starbucks and you legally open carry an AR on a sling into that Starbucks, you have 100% of my attention. You have 100% of my attention because it's not normal to do that. So a guy comes into a classroom with a gun. Let's pretend the university didn't ban weapons. That's not normal. That's not normal. He has 100% of my attention right then. Then, of course, he shoots the instructor, shoots 2 other people. Obviously, now he's committing crimes of violence, terroristic acts. Can you use deadly force to stop that guy from hurting you or hurting other people? The answer is unequivocally yes. The legal question is, are you reasonably perceiving an imminent threat of death or serious bodily injury to innocents? So long as the answer to that question is yes, you can use deadly force to stop that guy. Now, importantly, the moment that answer to that question is no, you have to stop using force against that guy, however much you think he deserves additional force for the horrors he's committed. So the law of self-defense does not allow you to use force to punish people, to seek retribution against people, vengeance against people, to hold them accountable for the wrongs they've committed, the lives they've taken. That's not what self-defense law is for. Self-defense law allows you to defend yourself and other innocents against a reasonably perceived imminent deadly force threat. And that's the limit of the legal boundaries there. It's not that hard for people to exceed that boundary. It happens all the time because we're humans, we're imperfect. Many people don't know where the legal boundaries are. They think they're allowed to use force in a broader way. It's not true. And unfortunately, if you step over the boundary, you don't just diminish your legal privilege to use that force. You don't just diminish your legal defense of self-defense to a criminal charge that might result. You completely lose it. Self-defense goes away. It's obliterated. If you use force, deadly force, and the answer to that question, when you use the deadly force, were you reasonably perceiving an imminent threat of death or serious bodily injury to yourself or other innocents? If the answer is no, you have no legal privilege to use deadly force against that person. Now, of course, there are human factors to take into consideration if you're lawfully using deadly defensive force and the conditions that justify it end. It takes time to process that, to realize you no longer need to use force. So if you're firing, 4 quick shots in self-defense and the first 3 are clearly legally justified and the last one, the bad guy had dropped his gun, was no longer a threat, you're not going to go to prison over that 4th shot unless there was a lengthy delay between the 3rd and 4th shot. And during that delay, the threat was neutralized, and a reasonable person in your position would have realized the threat was neutralized. And then you shoot again. That can be a problem. That 4th shot then might not be justified because there was no longer an imminent threat of death or serious bodily injury to another. Imminence, this element of imminence, in fact, I'll just step through the 5 elements, the up to 5 elements of any claim of self-defense. These are the building blocks for a claim of self-defense. The elements that must be present unless one or more is legally waived. And often one or more is legally waived. The good news is there's not 500 of these things. There's not 50 of them. There's only up to 5. So it's not rocket science. The elements of self-defense are innocence, imminence, proportionality, avoidance, and reasonableness. Innocence, that you're defending innocence. You're not the aggressor in the confrontation. You're defending yourself against the aggressor. That's the element of innocence. Imminence, the threat you're defending yourself against is either actually happening or immediately about to happen. The gun's being drawn, the fist is being pulled back. You're not required to suffer even a scratch before you can defend yourself, but you have to be about to have suffered the injury that's apprehended. You can't be defending yourself against some past threat or attack that's over, you can't be defending yourself against some speculative future threat that may never happen. The threat has to be imminent. Excuse me. The third element is proportionality, which basically means you can't use deadly force in self-defense unless you're facing a threat of death or serious bodily injury. You don't need to be facing death. Serious bodily injury is enough. Broken bone, loss of bodily function, loss of consciousness. But something like a mere punch to the shoulder would not qualify. If you use deadly defensive force when you're not facing a deadly force threat, death or serious bodily injury, you're using excessive force, you violated the element of proportionality. Avoidance generally is not required. It is the element of the five that's most commonly legally waived. It has to do with whether or not you have a legal duty to retreat before you can use deadly force in self-defense. There are only 11 states that are duty to retreat states that impose a generalized legal duty to retreat before you can use force in self-defense in an otherwise lawful case of self-defense. Even in those 11 states, however, you only have that duty to retreat if it's possible to do it with complete safety. You're not required to increase your jeopardy in an effort to retreat. You're not required to leave anybody behind, any innocent behind. It's only if safe retreat is possible for you and anyone else you would have a duty to protect. That's 11 states. The other 39 states are appropriately understood as stand your ground states where you don't have this generalized duty to legally retreat in an otherwise lawful case of self-defense. So the element of avoidance in those 39 states is effectively waived in otherwise lawful self-defense. And then you have the element of reasonableness. So everything you're perceiving, all your decisions, all your actions have to be those of a reasonable and prudent person in the circumstances. Your perception of the threat can't be speculative, it can't be imaginative, it can't be simply the result of bare fear, an irrational fear. It has to be that of a reasonable and prudent person. And there's no irrational, reasonable, and prudent person. Now, this model of the reasonable person is customized for the circumstances, which include the physical circumstances where this is happening. It includes your specialized knowledge, if you have specialized training or expertise. It includes any exceptional fighting abilities you might have. It includes physical disabilities you may have. So, for example, you're in a duty to retreat state. You're supposed to run if safely possible before you act in deadly force self-defense, but yet you have artificial hips or bad knees or whatever. You're old and slow, like some of us tend to get if we live long enough. That would change the analysis for whether or not it was possible for you to safely retreat. So innocence, imminence, proportionality, avoidance, and reasonable. And that element of imminence can be thought of almost like a window, right? There's a danger you're perceiving. Maybe it's not imminent yet, but it becomes imminent. The window of imminence opens. Now you're privileged to use force in self-defense, but then the window of imminence can close. The threat becomes neutralized, either because they just choose to, they run away, they realize they brought a knife to a gunfight, they give it up when they see your gun, or you neutralize the threat. But once the threat's no longer imminent, your privilege, your legal permission slip to use force against that threat's over. It ends, again, with reasonable allowance for human reaction times. So this guy comes into, Mahomed Jalloh comes into the class, asks if it's an ROTC classroom. Then he shouts, Allahu Akbar. Could you use deadly defensive force against him right then? Imagine one of these students is carrying a SIG 365 in an appendix holster, and this dude comes in with a long gun, shouts Allahu Akbar. Can you shoot him right then? I think you can certainly make the argument, right? Is that not a shout made immediately preceding acts of deadly force violence routinely? Routinely? Could it be a joke? Could it be a prank? Sure. Guy could walk in with a fake smoking bomb too. That could be a prank. He could walk in with a fake gun that can only shoot a little red flag out the front of the muzzle. Just a prank. But if you reasonably perceive it as an imminent deadly force threat, you're meeting the conditions for the use of deadly defensive force. And your perception doesn't have to be correct. The law doesn't require perfect decisions in self-defense. The law only requires reasonable decisions in self-defense. Mistakes are permissible. Oh, I really thought that was a real gun. Turns out it was a toy. Turns out it was an airsoft. Mistakes are permissible in self-defense so long as they are reasonable mistakes. Of course, he doesn't just walk in and shout Allahu Akbar, then he starts shooting people. So at that point, clearly deadly defensive force is warranted. By the way, in this kind of shooting, it raises an issue that's not common to the typical self-defense scenario, by which I mean, someone breaks into your house, or you're the victim of an armed robbery at a gas station, a guy's standing, 8 feet away with a pistol, give me your wallet. Those tend to be short-range encounters. And this was a short-range encounter, too. It was in a classroom. But imagine if this guy had started shooting people outside the building, just in open terrain. College campuses typically have, expanses of space. Or this could be in a big box store where there's 100, 200 yards linear distance within the store. Something like this goes down. In traditional self-defense cases, if you're using a gun in self-defense, you're almost always in close proximity to your aggressor. But in these kinds of events, it's often not the case. Often the bad actor is at a considerable distance. Can you hit something at a considerable distance with a handgun? Whatever handgun you actually carry, not your best gun that is a safe queen, but with what you have on your person. Do you know how far out you can reliably get hits and not just be sending rounds around the community, endangering innocent people? Now, I'm not telling you have to be able to hit a man-sized target at 200 yards or 100 yards or 50 yards. I'm not telling you anything. I don't tell people what to do. But you should know what that distance is for you, what the distance is at which you can hit reliably a man-sized target with whatever gun you carry on your person. And you should understand what that distance looks like in different environments. So if the worst happens, you know what you're capable of. You're not going to learn to shoot at distance in the moment of crisis, right? So this guy comes in the classroom with the rifle, shouts Allahu Akbar, starts shooting people. Clearly, you can use deadly defensive force against them. Now, of course, here, nobody in the classroom had a gun. Somebody had a knife. I guess a bunch of other people grabbed this guy, too. Are you privileged to kill him? To kill this guy? And the answer, technically, believe it or not, is no. You're not legally privileged to kill him. Even though he just shot the instructor and shot 2 other people, your legal privilege is not to kill. The law of self-defense does not privilege you to kill people. It privileges you, under the appropriate circumstances like here, to use deadly defensive force. Now, deadly defensive force may well result in that aggressor's death. But the death itself is incidental. So to illustrate, for example, if you shoot the guy and he loses consciousness and he's no longer an imminent threat, can you shoot him again to kill him? No, that's not what the law of self-defense allows. The law of self-defense allows you to neutralize that person. It just happens that the most effective way to use deadly force, to neutralize a deadly force threat, tends also to be the best way to end up having that person expire. Speak for myself. Who else would I speak for? Have that person expire. But the death itself is incidental. It's not what the legal privilege provides for you. That's just what happens when you're doing what the legal privilege does provide, your use of deadly defensive force. Now, this guy was reportedly stabbed 22 times. That's a lot of stab wounds. I can understand why that might happen. How many times can you stab this terrorist killer? As many times as it takes. As many times as it takes to neutralize the threat. It's the same with, if they had a gun, how many times would they have been legally privileged to shoot them? Once? 5 times? 10 times? The answer is 500 times. The answer is an infinite number of shots, as many shots as it takes to neutralize the threat. By the way, that can be, of course, if you fire more shots, in some cases it can look bad or be made to look bad by a prosecutor. Maybe he argues that you only fired that many shots because you were in a rage. It was an emotional killing. It was not a rational killing in self-defense. You just did a mag dump. So it's worth being able to make effective hits, so you're using the least number of shots necessary to neutralize the threat. This can have an effect on things like ammo choice too, by the way. So, for example, 22 pistols, they kill a lot of people. 25 caliber pistols, .32 caliber pistols, especially in the hood. These cheapo guns, they kill a lot of people. They tend to kill them later. They tend to die sometime after they've been shot because the rounds are so low powered. They tend to die after they've had the opportunity to kill you, which is not ideal, right? If you're going to neutralize a deadly force threat, you want to neutralize it as promptly and efficiently as possible. Now, one issue, of course, here with the 22 stab wounds is as long as this guy remained a reasonably perceived, doesn't have to actually be, but a reasonably perceived imminent deadly force threat, you can keep stabbing him. That can be 5 stabs, 10, 20, 22, 42, 102. Of course, you're going to have to explain to somebody afterwards why you reasonably perceived that 22 stabs were necessary. You can imagine a scenario here where this terrorist killer has been completely immobilized. He's been stripped of his weapon. He's pinned to the ground. His arms, his legs, they're all being restrained. He's not capable. He's no longer an imminent deadly force threat. If you then stab him 22 times, that would just be a murder. That would just be a murder because you're using deadly force against someone who's no longer an imminent deadly force threat. Now, there is, of course, a wrinkle here because of the fact that this guy comes in, shouts Allahu Akbar, and then starts committing terroristic murders. What's another common killing technique for Muslim terrorists? It's a suicide vest, right? In fact, I think the guys in Australia were perceived as wearing suicide vests. I don't think they were. I think they were wearing ballistic vests, but it was a reasonable concern of people engaging. Would it be reasonable to have a concern that someone who walks into a classroom, shouts Allahu Akbar, starts shooting people, might have rigged himself to go boom? So could be a continuing lethal force threat even if you've taken his rifle from him? Maybe. Maybe. Let's see. What else did I want to cover there? Oh, let's talk about the knife thing. So the university had a rule against knives on campus. I don't know if there's a Virginia statute against knives on campus, a criminal statute. So this would be a criminal violation subject to prosecution. If not, then it's just a university rule. I guess they could kick you out of school. That would be about the limits of what they could do to you. If it's a criminal violation, then of course you could be prosecuted for unlawful possession of a weapon. Like in Massachusetts, for example, it's against criminal law to have a weapon on a campus. So could the guy, the hero, who stabbed this terrorist killer, could he face let's pretend Virginia has a criminal statute against knife possession on campus. Could he be prosecuted? I mean, didn't he stab this guy to save a life? But could he be prosecuted? The answer is on the weapons charge. The answer is yes, he could. And you might think, but if the stabbing was lawful, if that was lawful self-defense, a killing of another human being was simply not a crime because it was lawful self-defense. He used the knife to save the day. How could he be prosecuted for knife possession? Well, because the weapons charge is completely independent of the use of force charge. Now, you could have imagine a scenario where the student says, oh, no, you don't understand. I didn't carry the knife into the classroom on my person. I was not violating that rule. The knife was already in the classroom. I don't know how it got there. There was just a knife there. I happened to observe it. And then when this guy came in, I picked up the knife and stabbed him to save everyone's life. Now, technically, that transient possession of the knife would also be against the rule, I guess. But that could be justified as under self-defense. You broke the law, technically, by arming yourself with a knife for the purpose of lawful self-defense. But it's different if you're just carrying the knife on your person. Then you are already violating the rule without the excuse of self-defense. So it helps to know these things because you can imagine that if someone questions the dude, the hero who had the knife, what he says could create legal liability for him or not, depending on what he says. And most people don't know these things, which of course is why We have lawofselfdefense.com. We have our free book, Law of Self-Defense Principles. Link is right there at the bottom of the description. Let's see, what else do I want to cover here? Even if the other students who neutralized this threat did something wrong, even if they used force after the threat was obviously no longer imminent, maybe out of a righteous sense of rage, could they be prosecuted for that? Theoretically, yes. If you don't have a legal justification for your use of force is simply unlawful. It'll be a crime. In this case, it could be the crime of murder, right? If the killing of this terrorist was not lawful for whatever reason, then you don't have the legal defense of self-defense. You're simply subject to the crime that the actions would support. By the way, that's an artifact of how we structure self-defense in America. It's a defense of confession and avoidance. In other words, you're not saying, it's not like an alibi defense, right? So someone's dead. The cops say you did it. They're going to charge you with murder. An alibi defense would be, no, I didn't do it. I didn't do it. I was somewhere else. I got witnesses that can corroborate. I have an alibi. It wasn't me. That's not self-defense as a legal defense. The legal defense of self-defense is the opposite of that. You're saying it was me, right? I shot that guy. I killed him. But I did it in lawful self-defense. Confession, you're not confessing to a crime, but you're confessing to the underlying conduct. It wouldn't make any sense to say, I was someplace else and I shot him in self-defense, right? That's incoherent. So you're confessing to the underlying conduct. I shot that guy and killed him. And you're seeking to avoid criminal civil liability through the legal justification of self-defense, confession and avoidance. If you lose the avoidance component of confession and avoidance, if you lose the legal defense of self-defense, all that's left now is the confession part, right? All that's left from I shot and killed that guy in lawful self-defense, period, is I shot and killed that guy, period. So by the very nature of raising the legal defense of self-defense, you're basically giving the prosecutor what he needs for the criminal charge. Does that make sense? That then you have to justify. Now, of course, prosecutors have complete discretion on whether they want to charge or not, even if they believe they have the technical grounds to bring a charge and win at trial, prove guilt beyond a reasonable doubt. By the way, in a self-defense case, the prosecutor not only has to prove you guilty of the criminal charge, which is pretty easy in a self-defense case because you confess to the underlying conduct, they also have to disprove your legal justification of self-defense. And they have to do both those things beyond any reasonable doubt. They have to prove you guilty of the criminal charge beyond any reasonable doubt. Pretty easy in most self-defense cases for the reasons we just discussed. And they have to disprove your legal defense of self-defense beyond any reasonable doubt. It's the highest threshold of evidence we have in American law. And it's the biggest thing a defender has going for him if he finds himself having to justify a use of force as self-defense. You can make yourself genuinely hard to convict because of that threshold if you know what you're doing, if you know where the legal boundaries actually are. But let's imagine that the students in this classroom used too much force, used it longer than they should have. There was no longer an imminent threat, whatever the case may be. Could they be prosecuted? Potentially, but it becomes, would a prosecutor want to, is really the question. You would hope not, right? Of course, Virginia appears to be going insane. We saw the clip of that one, the Norfolk prosecutor. You know, he's blaming this on the gun. Was this Islamic terrorist in his mind just a helpless actor? Shouldn't have been killed. They didn't have to kill him. They went too far. I mean, we see those prosecutions happen, right? George Zimmerman, cleanest self-defense case I've ever seen brought to trial. Got prosecuted. Kyle Rittenhouse didn't shoot anyone, not trying to kill him. Still brought to trial. It happens all the time, especially with these George Soros type prosecutors. You know, you could do everything right in a self-defense case and still be in jeopardy, right? I mean, physical jeopardy and legal jeopardy. You could do everything right, acting in lawful self-defense, and you run the physical risk of dying in that fight, right? There's no magic pixie dust that says the good guy wins the fight. Could not be your day. You can reduce the risk of losing the fight by doing things like arming yourself, training yourself, and every responsible adult should do that. You can reduce the risk. You can reduce the risk of losing the fight quite a lot. But the risk is never zero. The risk of losing the fight is never zero. Once you go hands-on, there's some greater than zero risk you lose the physical fight. And the same is true for the legal fight. You can do everything legally correct, and there's still a chance you get convicted. That's just the noise in the system. There's at least a 20% chance if you're put in front of a jury, even in a clean case of self-defense, that jury will convict you. Maybe irrationally, maybe they're just not very bright. That's just the noise in the system. And prosecutors know this, by the way. So prosecutors know that even if they don't have a good case on the legal merits to overcome your claim of self-defense, there's always that random 20% they might get a conviction anyway. That's why they went after guys like George Zimmerman. They knew they didn't have a conviction on the merits, but they were hoping they'd luck into that 20%. Who knows? You don't know what kind of jury you're going to get. And so you could do everything right and still end up getting convicted. Now, you can reduce the risk of getting convicted a lot, just like in the physical fight, by stuff like this: training, right? Arming yourself with knowledge, knowing where the legal boundaries really are. And if you do that, you can get the risk of being convicted really close to zero. You can be genuinely hard to convict, but the risk is never zero, always greater than zero. So I don't tell people what to do. I don't tell people when to fight, not when to not fight. But I want you to think about it for yourself now, because the time to think about this is not when you're getting your ass kicked in a parking lot, right? The time to think about, under what circumstances am I prepared to risk death and life in prison? Because that's what you're doing, especially when you get into a deadly force fight. Let's see, a couple super chats here. Let me hit these and then I'll look over at the Law of Self-Defense website again. Can the imminent window close and reopen? It can, sure, right. It all depends on the circumstances. I mean, for example, you're the victim of an armed robbery at a gas station, right? You're pumping gas in your car. Guy turns the corner of the car with a gun in hand, says, "Give me your wallet." You pull your own gun, you shoot that guy. He falls over unconscious. You've neutralized that threat, right? Can't keep using deadly defensive force. But what if he's not actually unconscious? What if he falls to the ground and he still has his gun in his hand, or he regains consciousness, right? Let's imagine that. So he genuinely lost consciousness, so he's no longer a deadly force threat, but then he regains it. Well, now he is a deadly force threat again. So the window of eminence has opened again. You can imagine lots of scenarios in which that might be the case. Dirt cheap, $2. Oh, I forgot a ka-ching for the last one. Sorry about that. Dirt cheap, $2. So it's a legit self-defense case unless the DA is named Binger. Yeah, I mean, it depends on what you mean by, a legit self-defense case. I mean, I would say it's a legit self-defense case if there's evidence to support, even minimal, even a scintilla of evidence to support each of those elements of self-defense we talked about: innocence, eminence, proportionality, avoidance, and reasonableness. That's a legit self-defense case. If you have no evidence on one of the required elements, the judge can deny you the right to argue self-defense. You don't technically meet the conditions for the legal defense of self-defense. So he cannot allow you to argue it to the jury. The jury could never hear the words self-defense in that trial. So what I consider a legit self-defense case is there evidence on each of those elements that the prosecutor cannot disprove beyond a reasonable doubt. That should result in an acquittal. That's what the jury would be instructed to do. But that can often be contested, right? I mean, listen, the truth is, one of the reasons there's a 20% chance of conviction, no matter how genuinely legit your self-defense was, is the people evaluating that question, right? Has this claim of self-defense been disproven beyond a reasonable doubt? By the way, he doesn't have to disprove the entirety. The prosecution does not have to disprove the entirety of your claim of self-defense. He only has to disprove any one of the required elements beyond a reasonable doubt. If he does that, self-defense evaporates because the elements are cumulative. They're all required unless one or more has been legally waived. But the ones that have not been waived, the required elements are required. If he disproves one of them, beyond a reasonable doubt, you have no legal defense of self-defense. And the reality is the people evaluating that question, has he done that? Has he disproven any one of the required elements beyond a reasonable doubt? They were not there when this all went down. They were not in this classroom, right? They were not at your self-defense. I mean, you're not going to be attacked while a cop is standing next to you. That's not what happens. The judge was not with you when you defended yourself. The prosecutor was not with you. The jury certainly was not with you. So none of these people actually know what really happened. They don't understand what happened in any absolute sense of truth. They're just being told stories in a courtroom, a story of guilt by the prosecutor, a story of justification by the defense, and they decide which story they find more compelling. And they could be wrong. Juries are not required to be perfect. They're not required to determine guilt beyond all doubt. They're required to determine guilt beyond any reasonable doubt. They're allowed to be imperfect because the system has to allow for imperfection. Let's see. Rumble Rant, $5. Thank you. It says POTUS called Martin his son, which opened the door for Zimmerman's prosecution. So that was Obama called Trayvon Martin. If I had a son, he'd look a lot like Trayvon Martin in the Zimmerman case. Yeah, there was a lot of, racial agitation. Obviously, George Zimmerman, well, he was Hispanic. For the first time in my life, I heard the phrase white Hispanic. So they tried to characterize, they lightened his photo, George Zimmerman's photo, in news reports. George Zimmerman was actually like the least racist person you can imagine. I didn't know George at the time, but I've come to know George since then. A really nice guy. Almost too nice a guy, frankly, for his own good. Completely non-racist. I mean, he actually, before the shooting, he got in trouble with the local police because he protested the local police treating black kids in the neighborhood severely. He protested them in defense of the black kids in the neighborhood. The FBI, after the shooting, the FBI sent teams of agents through this apartment complex looking for and it was very racially mixed apartment complex, looking for any black residents who would say that George Zimmerman had ever done anything that looked racist to them. They all loved George Zimmerman. One of them testified at trial, a big black woman. His neighbor testified. She adored George Zimmerman. He was always helping her out and doing favors for her. It was great. But, he was not black, and he shot a 17-year-old black man. And so they, of course, that racially energized the case. Al Sharpton came to the area. The real reason the case was brought, many people don't know this, so I'll go ahead and share this. The local the local prosecutor where it happened, he actually quit rather than submit to pressure to bring charges against George Zimmerman. That's how clean of a self-defense case this was. The local prosecutor quit rather than be pressured into charging George Zimmerman. But when he quit, he opened up the door for the governor to appoint a replacement prosecutor. And the governor appointed a prosecutor from Jacksonville, a different part of Florida, who was having a big problem. She was running for re-election, and she had prosecuted in some high-profile cases some black defendants, and she was being made to look racist for having prosecuted those particular black defendants. And there were protests against her in her election. And Jacksonville has a lot of black people in it, and she was going to lose re-election. And then she saw the opportunity to step, and she's a white woman, she saw the opportunity to step into the George Zimmerman case, initiate a prosecution against him. And suddenly the protests were not against her anymore. The protests were against George Zimmerman. And she was at the head of those protests, marching with them. So, her goal was to save her reelection. And it worked. She lost the case. Zimmerman was acquitted, but she won. Angela Corey won reelection. So it's a problem with many of these cases is that the prosecutors, when they bring these illegitimate cases, they're bringing them in part because it's a win-win for them, right? Even if the case has no legal merit to get a conviction, there's always that 20% chance of conviction, and then they can say, see, I told you so. He's guilty. Jury said so. I won the trial. But even if they lose the trial, like Angela Corey lost the Zimmerman trial when he was acquitted, she won her real strategic objective, which was reelection. So there's no downside for them. No downside. Old dog, new trick, $5 says, if you're in unlawful possession of a weapon, could you lose on innocence because you weren't lawfully present? Generally not. So you can be committing some other crime and you don't lose your privilege of self-defense. If the crime you're committing is an act of violence that would lose one of the elements of self-defense, of course you would lose self-defense. But if you're committing a crime that's not that, say you're a street corner drug dealer, right? You're committing a crime. You're illegally dealing crack on the street corner. If someone tries to commit an armed robbery against you, which is an occupational risk of street corner drug dealers, you can defend yourself lawfully against that armed robbery. You don't lose your right of self-defense because you're dealing drugs. You're on the hook for dealing the drugs, of course, but you still have your privilege of self-defense. Now, there are issues that can arise. For example, if you're in a stand your ground state, a lot of stand your ground states, about half of them, do condition stand your ground, being relieved of a legal duty to retreat. Do condition stand your ground on not being engaged in unlawful activity. So in that circumstance, the street corner drug dealer committing a crime, dealing drugs, would not lose self-defense per se, but he might lose stand your ground. He might reacquire that element of avoidance, that duty to retreat that otherwise would not exist. So there are issues around the margins like that. But generally, you don't lose self-defense entirely because you're committing some other unlawful act. Unless the unlawful act would, violate one of the elements of self-defense. Dirt cheap, $2. Or horrible jury instructions like the Apple River Mew case. Yeah, so Nicholas Mew on the Apple River in, I forget, Wisconsin or Minnesota, stabbed a bunch of people who were attacking him, teenagers who were attacking him, got bad jury instruction. The Ahmaud Arbery case with the McMichaels, and is it Roddy Bryant? Is that the third defendant's name? Ahmaud Arbery, the jogger in Georgia, bad jury instruction. Judge just didn't do his job. That's part of the 20% too, especially in politically energized cases where the judge does not want to put their neck out to benefit a politically disfavored defendant. Joshki, $2 says, idea, Branca ties to go along with the coffee mugs. Yeah, we have Branca mugs, by the way. Branca for SCOTUS. I often talk about unelected black robe, tyrannical, inferior federal district trial court judges. We'll be doing that when we transition over to our members only show in just a moment. Membership's only 16 cents a day, folks. $5 a month to be a member of this channel. Get double the number of Branca shows. Or if you don't like to give YouTube money, that's fine. You can be a member on Locals. Same thing, 16 cents a day, $5 a month. The links for membership and the links for this members only show are all in the description. The link for mugs is the first link in the description of this show. I'll take that under advisement, Joshki. That's not a bad idea. And another look at the Law of Self-Defense membership page. Here it is. Yeah, so this is a good point. Jeffrey at lawselfdefense.com says, Your Honor, I didn't stab him 22 times. Let me move this back so people will know what I'm talking about in this show. I didn't stab him 22 times. It's not my fault. He kept struggling, rolled on my knife 22 more times. Is it possible that if a bunch of guys are wrestling with this killer, that just that physical movement would lead one to believe the killer's still resisting, is still an imminent deadly force threat? That's one of the circumstances that would be part of the totality of the circumstances that feeds into your reasonable perception of threat. JR says, breaking. Suspect known as Muhi Mohamed Naj allegedly enters Texas elementary school with military gear and a firearm. Is that right? Let me do a quick search on that. 15 hours ago. Man arrested on felony charge after entering an elementary school. Armed and in tactical gear. Dressed in military-style clothing. carrying a multi-agency investigation. Kyle Naj Chris, also known as Muhi Mohamed Naj, might be an American-born citizen who's been radicalized into ISIS. He entered the front office after slipping through the front entrance when another visitor failed to fully secure the door behind him. Yep. Employee asked him how he entered without access. Let's see. He then just left the building, got in his car, and drove away. I guess they got his plate number and called the cops. Well, he didn't. Oh no, they used the Flock license plate database. That's how they got him. We have those Flock readers all around my town. Thanks, JR. I'll keep an eye on that. Yeah, I believe the rifle used in the Old Dominion shooting, the gun used was a rifle, was a long gun. Jeffrey asked, question, based on your hypothetical that it's permitted to carry a gun and he's open carrying, but hand is not on the gun when he shouts Allahu Akbar, does that pass the reasonable test when it's only words at that point? If so, is it reasonable to shoot anyone saying that if they're concealed carrying? So generally words alone, literally words alone, are never enough to constitute an imminent threat. The words can be threatening. The words could be, I'm going to kill you. But if it's only words, that's not enough to constitute an imminent threat against which you can use defensive force. What's also required is an overt physical act consistent with the threatening words. Now, it doesn't need to be much of an act. Someone says, I'm going to shoot you, and they reach for their waistband. That could be enough together to qualify as an imminent deadly force threat. Someone walks into a classroom, shouts Allahu Akbar just with a rifle slung and just stands there. That might not be enough. But if they put their hands on the rifle, that's the overt physical act that would be arguably sufficient to qualify now as an imminent deadly force threat. Chris asks, when did he display the firearm and what firearm was used? I think it was a rifle. So I think it was displayed, visible the moment he walked in. Jeffrey says, juries are always scary. Massad Ayub, by the way, Massad Ayub wrote the foreword to my book. Calls them a 12-headed dragon with a combined IQ of 1,200. It's not always 12. It's not always 12. George Zimmerman was tried by a jury of 6, for example. Let's see. And I would be surprised if every member of a jury had 100 IQ. Let's see. I think I may have everything. Any more super chats, Rumble rants? There is another Rumble. Nope, got that one already. All right, guys, at this point, we're going to get ready to transition into our members only show of the day. Before I go, don't forget, get your book, Law of Self-Defense Principles. We give it away. Check the reviews on Amazon, but don't buy it there. They'll charge you for the book. We only ask you to cover the cost of shipping the book to you. lawofselfdefense.com/free book. Right there in the bottom of the screen. lawofselfdefense.com/free book. I'm going to take that banner down there as I get ready. So this is the part of the show where we launch the members only stream. Even before we exit here, this show is about a decision out of the Ninth Circuit Court of Appeals, which covers California and Oregon and Washington State, some other territory. It's a case involving Washington State, a Korean-style spa for women and girls as young as 13. Korean-style, part of that is they bathe in communal tubs, groups of people, of women and girls as young as 13, in the nude. This Korean-style spa, run by Catholics, was sanctioned by the state of Washington because they would not allow in as customers men. Now, the men would say, well, I'm actually a woman. I'm a transgender woman. But they had all their junk. They're fully intact males who want to bathe in the communal tub, swinging left and right, the junk in plain view in front of these women and these 13-year-old girls. And the spa said, we're not doing that. And Washington said, yeah, you're discriminating against transgender women if you don't. So it went to federal court, went to Federal Court of Appeals, Ninth Circuit, and the Ninth Circuit just handed down their decision and said, yeah, you got to let these swinging man junks into your spas, into your communal pools. And that triggered a bunch of responses from several Trump-appointed members of the Ninth Circuit Court of Appeals that are fiery, especially from Judge Van Dyke, who does great work on Second Amendment issues as well. His is so fiery that some of the judges on the other side wrote not about the case, but just to object to how heated Van Dyke's dissent was. By the way, the three-judge panel that said the spa has to allow these people in, it was a 2-1 vote. 2 judges, the majority, voted, you got to let the guy with the man meat into your communal tubs with the women and girls. Both of those judges, Clinton appointees, both of them, they're both in their 70s. One of them's a woman. The judge who dissented on the 3-judge panel, a Trump appointee in his 50s. Why can we always predict these legal outcomes based on the president who nominated the judge? Isn't that weird? Imagine a 78-year-old woman, just judge on the Ninth Circuit Court of Appeals, ruling that this little tiny business in Washington State, family-run, Catholics, Korean-style communal tubs, they have to let not just men in, transgender women, I mean, crazy men, have to be allowed in to bathe with those women and girls. Unbelievable. Anyway, that's what we're going to break down in the members-only show. So I hope to see a bunch of you over there. I'm going to go ahead and get that show ready to launch. And Steve is already there. He's already waiting. I'm going to launch. Oh, got to get my music going. The background music going. All right, that's right. That members only stream is launching right now on YouTube and on Locals. The links are in the description for this show. You may be auto-redirected over there if you're on YouTube. I hope to see a whole bunch of you there. Until then, I remain attorney Andrew Franklin for the Franklin